University Law School. My Twitter feed lit up yesterday afternoon, and I immediately flipped on the. It's kind of like one of those multitasking things. Flip the radio on, turn the TV set on, to find out that the circuit attorney has dropped the charges against Governor Greitens. The defense team is saying this is a great victory. I have a slightly different take on this because there was no victory because there was no jury impaneled. It seems to me that the linchpin on this whole thing was when the circuit attorney sat in on a deposition with the fellow from Michigan, and by doing so, that opened her up to being subject to being called to the witness stand. And that's the reason, and she didn't want to do that at all.
She did not want to because she could not. See if we can set the stage, Doug and Kelly, for our listeners. The investigative phase of this charge against Governor Greitens involved independent investigators who had been hired by the circuit attorney. That was highly unusual from the get-go. Normally you would have detectives and police officers from the city of St. Louis who are highly skilled, highly experienced investigators. But for whatever reason, the circuit attorney chose to go a different route, and she hired, among others, this Mr. Tisby.
Okay.
Mr. Tisby then interviewed KS, the victim. Subsequently, Mr. Tisby's deposition was taken. And in both of those instances, the circuit attorney, Ms. Gardner, chose to be present. At his deposition, he, among other things, testified he did not take notes and that there was no video of the interview. Well, subsequently, it came out that there was a video. It was turned over to the defense, and guess what, Doug and Kelly?
There sat
Mr. Tisby taking notes. So fast forward then to getting ready for the trial. The defense, of course, wanted to impeach the evidence that the prosecutor was going to put on, and they endorsed. They said they were going to call Kim Gardner as a witness. And Judge Burleson agreed.
Okay.
So there was a flurry of motions filed under seal over the weekend, and Judge Burleson yesterday morning ordered that Ms. Gardner could testify. They took an emergency, what's called a writ, we lawyers call it a writ, up to the Court of Appeals. Midday yesterday, the Court of Appeals denied the request. So by 3 o'clock in the afternoon, Ms. Gardner was confronted with a fact that she is the prosecutor and she is a witness. And it is black letter law, Doug and Kelly, for us lawyers. You cannot be an advocate and a witness. So at that point, in her mind, she had to dismiss the charges. There are some who say, well, she should have just handed it off. I don't think that was practical, to hand it off to somebody who hasn't been involved. But the decision that she made as sort of the first step, that I can't proceed, was solid because a lawyer cannot be an advocate and a witness.
But if she had handed it off to someone who had not possibly been involved, I mean, that's what she's going to have to do anyway. But you're saying they would need the time to investigate and to get up to speed?
Well put, Kelly. I think it's unrealistic to turn to Jane Smith, a hypothetical Jane Smith in the circuit attorney's office, and say, go girl, get ready to try this case Thursday morning. We're impaneling the jury now. So I think that would have been unrealistic. What we're faced with now, the second part of your question, Kelly, is the possible refiling. The circuit attorney issued a statement yesterday and said that her office intends to refile, and she said that she will either seek the appointment of a special prosecutor or have an assistant in her office, a Jane Smith, designated to get ready and refile the case.
Now, the defense attorneys are saying this dismissal occurred because of misconduct by Gardner, and therefore wouldn't qualify for more time to refile. Sounds like lawyers are. If Rex Burleson, the judge, is planning on taking a vacation time anytime soon, I don't think he's going to get that.
He needs to call our friends at Altair Travel and get out of here, Doug.
Okay. So for the time being, this is where we stand. This particular phase has come to an end when it comes to the governor. He still has two other things that are hanging fire out there.
At least.
At least right now, officially, there are two other things that are in there. Was the circuit attorney's office basically out-lawyered on this, do you think? I mean, it's an opinion, I know, but it seems to me that this business with Gardner, I mean, they had to know about this. And the fact that these particular items were filed under seal over the weekend, and obviously everybody knew about this.
Well, I think, answer your question in two ways, Doug. Were they out-lawyered? I'll answer it this way. And I've said this on the air before. I think the three of us talked about it last Friday. The team of Jim Bennett, Scott Rosenblum, Ed Dowd, et al. Is as fine a team as you're going to get from Bangor, Maine to San Diego. And they did a terrific job. They also, however, both sides were left with this reality. It was a horrible, horrible case to prove in court, and the four elements that we talked about on the air last week. So as to his other messes, you're right. He has the criminal case for felony computer tampering.
Right.
That's pending in the city. He has the case pending in civil court, I think in Cole County, dealing with the Confide app. And Friday, the legislature is going to call itself back into special session for the impeachment process. So all of that continues, and to put a great big exclamation point on a Tuesday morning, not one thing, Doug and Kelly, that happened yesterday has a scintilla of an effect on any of those other matters, especially impeachment.
But how do you think some of these lawmakers, how do you think they will react since the case was dismissed? And how will that influence them in the impeachment process?
I think you could probably divide them into a few groups, Kelly, but you have a few diehards that he could have been convicted and would have taken sort of the Bill Clinton impeachment view. Well, he was convicted about invasion of privacy dealing with a private sexual matter, and that we're not going to impeach him for that. Then I think you had some who legitimately said, you know what, we're not a judge and jury, but I'm going to wait to see what a jury says, and I'll let them decide. And which, as I've said on the air, I think is inappropriate constitutionally. And then there are others and I think the bulk, I guess to answer your question directly, Kelly, I think the bulk of representatives in Jefferson City recognize that they have an independent constitutional responsibility to decide whether the conduct that Representative Barnes' committee is going to present to them, whether that conduct is an impeachable offense, irrespective of what happened in the city circuit court.
Here's another question that we sort of tap danced around last week. For the circuit attorney's office, it's, if you will, by the hour. They're salaried employees, everybody who was working on this case. Granted, there's probably some overtime involved, but we, the taxpayers, that's part of what we pay in taxes in the city to do this. For Governor Greitens, I'm thinking there's some very serious billable hours that are coming up there. Who's going to end up? I think the governor has set up like a GoFundMe campaign. I mean, this to me indicates this is going to be a very, very expensive bill that he's going to be facing here, and soon.
It has been and will continue to be very expensive, Doug. You are correct. He has a fund that has been set up, not certain from whom donations are being made and how much. That certainly is very opaque.
Yeah.
Jim Bennett said on the courthouse steps last night as part of his press conference that I think I'm pretty close to verbatim. The governor is paying my firm directly. Now, is the governor then getting reimbursed from this legal defense fund? Who knows? But you're absolutely right. This is going to continue to be very expensive. In contrast, the circuit attorney, those folks will come to work. But and I guess related to that, I'll just make this comment. A lot of people are saying, golly, that was a tough blow for the circuit attorney in her office to take. I would strongly disagree. Whatever blow the circuit attorney took, if the phrase self-inflicted ever had any meaning, Doug and Kelly, it has meaning this morning. All of this was 100% self-inflicted by the circuit attorney.
I was going to ask you moving forward for this other case against Greitens, and if the circuit attorney is going to handle that case, I mean, she's under a microscope now.
Well, she is, Kelly, and I think we can divide the two cases. On the felony tampering case, we won't have the same issues, I don't think, in terms of advocate and witness that were front and center yesterday. But there's also an interesting piece, is that she announced yesterday that she is going to refile the case, she says. Can change her mind, but that's what she said. And she said, it's either going to be an assistant in my office or I will have a special prosecutor appointed. Well, if she turns it over to an assistant in her office, I think we can all make book. It's going to be refiled.
Okay.
Our hypothetical Jane Smith a moment ago was not going to say, hey, boss, you're an idiot. You should never have filed this to begin with, taken it to grand jury. We're not going to refile it. But think about this for a moment. If she does, in fact, have a special prosecutor appointed, and let's say it's the assistant prosecuting attorney from Cape Girardeau County, and she comes in and looks at it, and she says, goodness gracious sakes alive, this case should never be brought, and I'm not going to bring it. Now, you talk about under a microscope at that point, Kelly, hold on to your hat. There's
also the possibility, too, if they refile, the circuit attorney could still potentially, unless it's a special prosecutor and not somebody in her office, might have to take the stand as well, which is sort of like you come full circle then.
Well, I think you're right, Doug. I think the underlying assumption has to be that if it is refiled, it is highly likely that Ms. Gardner is going to have to testify. Now, maybe if it gets that far and we have a trial, maybe Jim Bennett and Scott Rosenblum and others would say, well, we're not going to call her. But I think the assumption has to be whoever refiles it, assistant prosecuting attorney from Cape Girardeau or Jane Smith from her office, the assumption has to be Kim Gardner is going to have to testify.
And they've got that card. The defense has that card in their wallet right now, and they can whip it out whenever they want to. We need to go on. We've still got you on speed dial, Greg.
I know. We need more time with you.
Sometimes the wheels of justice grind very, very slowly, and sometimes for this brief fragment of time, this was just a whirlwind, and we'll keep an eye on it, obviously. Thank you very much for coming in today.
Fasten our seatbelts, Doug and Kelly. Good to be with you.
Greg Willard, adjunct professor at St. Louis University Law School, also our KTRS legal expert at 7:32 here on the Big 550.